Good morning, members of the court. Your Honor, I have Douglas Berry of the Nashville Bar on behalf of the appellant, City of Orlinda, Tennessee. I have a preliminary matter that I hope will not count against my time. It has to do with some exhibits.
All right.
We had three.
Have you discussed it with counsel?
I have discussed it with counsel. 3 trial exhibits, zoning 4, 8A, and 8B, all of which were stipulated to and admitted by agreement before the trial court. The trial court clerk believed were too bulky to transmit with the record. Experts might differ about that. I think the court needs these, honestly, and would love to, if we could, have them admitted and be part of the record here.
Mr. Harrison or other, do you all have?
I agree, Your Honor. It should have been brought with the record anyway.
Okay, all right.
As is Mr. Sutton.
All right, very
So
good.
We're totally agreed with that. We were told to give it to you for acceptance into the record. I've never done that before.
I haven't done that either.
I do what I'm told. Your Honor, I do what I'm told when courts tell me, and when court clerks tell me. I do what I'm told. Well,
if you will hand that to the Madam Clerk, and we'll figure out what to do with it. But it has been represented to the court that all counsel are in agreement that this should be part of the technical record, and at this moment I see no reason not to include it, but I'll confer with my colleagues.
It's actually listed in the index of what is in the record.
Okay.
Purely just too bulky, I think.
Well,
I had a case once where the clerk did not send it. I looked and looked in the record for something, and it turned out the clerk didn't send it because it was too bulky, and we made the clerk bring it up here.
Well, so, I've had some much bulkier items in my records before, but anyway. All right.
Well, there's more and more records, Your Honor.
Yeah, I'm sure we will be able to work this very difficult dilemma out to the satisfaction of all.
Thank you.
All right, Mr. Berry, we'll now start the clock. Do you want to save time for rebuttal?
I think I'll take 3 minutes for rebuttal, Your Honor.
3 minutes, all right.
Your Honor, this is a suit for declaratory judgment filed by the City of Orlinda challenging a rezoning of property right on the boundary of the city limits from agricultural to commercial, neighborhood commercial, on the basis that the property was completely surrounded by residential and agricultural zones for a radius of 2 or more miles. The court, northeastern Robertson County is a very rural area. And from a low-density residential and agricultural zone to a neighborhood commercial zone, and this was illegal spot zoning. Another issue we raise is whether or not the rezoning and the new zone was neighborhood commercial was proper, given the evidence that there was the proposed use of the property, which was a food market and delicatessen, was not intended to serve the needs of the immediate neighbors, as a typical neighborhood commercial was, but by the statements in the Appellee's, the Bernard's own application, was intended to draw customers from all over northern Middle Tennessee and southern Kentucky. Not a pretty large neighborhood. So those are the 2 substantive issues we raised. There's also a procedural issue about the failure of the county planning director to offer provide a written recommendation to the Planning Commission and County Commission. We don't abandon that argument, but we're just going to rely on our brief for that. Finally, an issue has been raised for the first time on appeal, but it's not one that can be waived, about standing. And I think I'll probably use my rebuttal time to talk about standing. Some salient facts, and I will say this. This case was tried toward the end, or perhaps not toward the end, in the middle of the COVID era, and we tried as much as we could to do depositions by video and also to stipulate to as many facts and documents as we could that would tell the court the story. Like the zoning maps, it's going to, there's some certain, word I'm looking for, it's a record you have to go through piece by piece, I'm afraid. And you got pieces of zoning ordinances, the long range, the comprehensive plan, a number of maps, photographs, and from all this to get the story, if you will. In this case, it's some particularly salient facts we want to point out. This property is 7 acres, and it's part of a larger tract of 14 acres, right partly in and partly out of the city of Orlinda. All of the surrounding property in the county, which is the zoning authority here, is zoned agriculture.
But the part in question is outside of the city of
It's
Orlinda.
outside of the city of Orlinda. I'll come back to that, Your Honor. And once again, for at least a 2-mile radius, by agreement with county attorney, we drew a circle around that that's 2 miles out, but you can look at the map and the colors on the zoning map and see how much of that is zoned and used agricultural. Really all the way to the Kentucky line, which is 3 miles. Much of the surrounding property, a lot of the surrounding property is owned by the Bernard family. They have a large farming operation, I think over 1,000 acres. They reside on Sparkman Road, which is, given the court will have to look at the map, probably 1.5 miles to the northeast of the city of Orlinda, where this store is. And there they had a farm store. And the court may be aware of the Right to Farm Act allows farmers to be exempt from zoning for essentially to sell their own produce and products. This particular property that's at issue in this case was not contiguous to the larger Bernard farms. It's not far away, but it's not the same tract at all. And one narrative that has crept into both the trial court's decision and into the briefs in this case, intentionally or unintentionally, is that somehow this store, which was approved as part of this neighborhood commercial zoning, is a continuation of the farm store, which was operated on the Bernard's property. That is absolutely not the case. There's no proof to support that. Contrary to that, there's a survey in the record that shows that it's unimproved property, submitted with the application for rezoning. There's a building permit that was issued by the county to build the building. It's simply not the case that this is a continuation of the farm store at this same site. And I think in part that was part of Chancellor McDonald's Chancellor's decision. McMillan's decision was
Chancellor McDonald had a farm, yes.
Oh, McDonald. Thank you, Judge Bennett.
You're welcome.
Bernard's first came before the city commission to feel the city out about whether they would allow this in the city. Got a no. They applied to the county, filed an application with the county for this use, and in that they described the use. A market and delicatessen, not to sell just their own products, but also those of others, dry goods, soft drinks, baked goods, barbecue sauce, flowers, and they would have a drive-through window. So not exactly a farm store, not exactly a...
Well, they don't claim to be a farm store with that.
No, that's true. That's why they sought rezoning. But in that application, there was a statement that we intend to be a destination for farm fresh meats and produce for the people of northern Middle Tennessee and southern Kentucky. Obviously, even if a business is for neighborhood, anybody can go there who can drive there. But that was part of their stated intention for the use of that property.
And that bothers you?
That bothers. I think that makes it not fit does not fit the definition of neighborhood commercial, which we'll get to in a second to get specific.
Okay.
Let me.
Yes, sir.
Go ahead.
Well, I believe you said the Kentucky line is only 3 miles away, right?
Correct.
Well, that's still kind of an area I would think the area they would serve would not be, limited to, is there some reason you limit the area you think they'd serve to 2 miles? Is that in the...
We're just trying to dramatize for the court how much this is an island, a commercial island within a green agricultural sea. The nearest population center in Kentucky, by the way, is Franklin, Kentucky, which is 10 miles away. That is in the record. So that's a little further than 3 miles.
Well, yeah, Franklin, Kentucky, they probably have stores they can go to in Franklin, Kentucky that were...
And they have horse racing.
Good point, John.
But But in saying you hope to serve northern Middle Tennessee and southern Kentucky, well, southern Kentucky 3 miles away, and you're in northern Tennessee right now.
Given the uses of those property, the part that's between this store and the Kentucky line is not going to support a store. You're talking about just huge farms. But
Well, then you need to draw people from further out.
I don't want to argue with the court, but I think that's
Yeah, right.
Our position is that this does not fit the definition of neighborhood commercial.
Okay.
But apart from that,
How big is the neighborhood?
well, it's a good question. We asked
Yeah,
the
thank you.
county codes official, and he said, I couldn't begin to guess.
Well, that might be a good answer.
Must be some reasonable definition of it, or otherwise the ordinance would make no sense. I'll come back to that. That's sort of our second
Judge
argument.
McClarty had a
Judge
question.
McClarty, pardon
Am
me.
I correct now, is this property proposing to be rezoned, is that completely outside the city?
Partly in and partly, yes. The part that, there's no question, it's completely outside the city, the portion that was rezoned in the county.
Okay.
That's correct. Yes, sir. The law is well settled on spot zoning, what it is. I think between the appellants and appellees, in this case, we've cited every Tennessee spot zoning case. I want to bring to the court's attention an error I made in my brief, and for which I apologize. On page 11, I cited some language from a case and cited it as id for the previous case, which is Phillips versus Tennessee Department of Transportation. It actually comes from another case which all parties have cited, and that is a Quoke 2 Fam versus City of Chattanooga, which is a spot zoning case, and that's where the language comes from. And just for the court's remind the court of the standards of that, and is that spot zoning pertains to when a single parcel or a limited area is rezoned for the benefit of a particular property owner, was or is inconsistent with the county, with the city, in this case the county's comprehensive plan, with the character and zoning of the surrounding area or the purpose of the zoning regulation, and the rezoned property is being treated unjustifiably different from the similar surrounding land, thereby creating an island having no relevant differences from its neighboring property. I would suggest that that is exactly what we have in this case. And if you look at the map, you'll see commercial uses are red. You're going to see an island, a red island in a green sea of agricultural and residential use.
Doesn't somebody have to be first? I mean, there are lots of rural areas that ultimately develop more of a, I don't even want to go as far as urban, but pop businessy area. I mean, somebody's got to go first. I mean, why is it unreasonable to have a market in an agricultural area? I mean, why is that so bad?
That's why. Well, I don't know that.
Why is it spot zoning? It doesn't just benefit the single parcel. It should benefit the area. They don't have to go into Orlinda. They don't have to go to Franklin, Kentucky.
Well, that was certainly, that gets to one of the rationales of the court, and also the testimony of the plaintiffs in this case as well. This benefits the city because it's a food desert. Orlinda's a food desert. Well, if it were, then prior to these folks applying to rezone their property, someone would have developed a grocery store in Orlinda. They would have. That's not for the. Otherwise, you could say, well, you need this pole is a pool hall. It has a dearth of pool halls. What you really need is a pool hall. What you really need is a filling station, and that would all. It can't be just up to the applicant for the rezoning. So somebody, the city fathers, in the case of Orlinda, city fathers and leaders, and with respect to the county, they have a land use plan. And what you would do to answer the court's question would be, in the normal case, would be to say, let's amend our land use plan and discuss why we need more commercial uses in these remote rural areas, and let's get a plan out there. But to do it on a case-by-case ad hoc basis is, as one of the cases says, the antithesis of good planning. So that takes care of my time.
All right.
Thank you.
Mr. Berry. Mr. Sutherland, will you be the only one arguing, or will you share?
Your Honor. Mr. Harrison have talked. I will obviously take the lead here.
I'm going to take approximately 8 or 9 minutes. If
All
I
right.
go over a little bit, if I go over under a little bit.
We'll set the timer for 8 and we'll let you figure it out.
All right, thank you. It please the court, your honors. Obviously, I'm Wes Sutherland. I'm here for the Bernards in this case, the landowners at issue. I'm going to go about this a little bit different based on Mr. Berry's argument and some of the court's questions so far. I think it's important to address first some of the statements about the city parcel versus the county parcel. Now, it's important to note that the Bernards did not file an application to rezone their city parcel with the city. There was no application filed. There was no determination made on that. What they did was they brought it to the attention of the city, specifically the city manager, Kevin Breeding. That name may ring a bell to you all in this case. Kevin Breeding is the only witness for the city of Orlinda in this case, and he just happens to be the neighbor directly across the street from the interested parcels at issue in this case. I would submit to the court there's a reason why he was the only witness, and that's the specific reason as to why the Bernards did not bring their city parcel into question, file the application for rezoning with respect to their city parcel, because they knew Mr. Breeding right across the street was not happy about what he felt was going on across the street or what was going to be attempted to happen across the street. Now, there's also an important distinction between what the Bernards brought forth to the city. It included a meat processing aspect of the proposal. It's important for the court to note that this has nothing, the current rezoning of the parcel, of the county parcel, and the farm store, there is no meat processing as a part of this application, nor as a part of the use. So there was never a formal application even filed with the city. The parcel at issue lies solely within the county. Now, brings up my first point that I want the court to bring to the court's attention. I want to begin with certain confusing maybe statements from the brief of appellant that I feel like there has been some misleading of the court with respect to what the facts are in this case. Number one, with respect on page 1, issue 1 of appellant's brief, he makes the statement, they rezoned property completely surrounded by ag and residential zones for a radius of 2 miles. That's simply not true. There is no radius of 2 miles around this parcel that is completely zoned residential and agriculture. If the court will just, I want to direct the court's attention to Exhibit 23. Exhibit 36 and Exhibit 4. Exhibit 23 was submitted to the court, and the purpose of Exhibit 23 was to state the distance from the parcel, the county parcel at issue, to the center of the city of Orlinda. That's only 0.6 miles. As a matter of fact, with respect to page 36 of the technical record of the city of Orlinda's own commercial business district, which is comprised of a half-mile radius from the center of the city of Orlinda, you can literally take a rock from this parcel and hit the half-mile radius of the city's, what's designated as the village center within their own plan. Within Exhibit 4, I'm glad Mr. Berry brought that up, because in Exhibit 4, you're going to see the Bernards parcel, and within that radius, within a 0.6 mile radius, you're going to see several previously zoned commercial parcels within that half-mile radius. We're not talking about 2 miles, we're talking about a half mile. And so I'll give you some examples that were in the record. There's the Orlinda.
But that's in the city.
It is in the city, yes, but within the confines of the radius of this property, because this property literally touches the city line, all of those commercial zones, or the commercial properties, are within a half-mile radius of this property. So to state that all of the rezoned properties are, I apologize. The rezoned property is completely surrounded by ag and residential zones for a radius of 2 miles, that's simply not true. That's just not true. And so I guess what I'm trying to say is to state that this is a commercial island in the midst of all of these other parcels, it is not representative of the facts of this case when you examine the entire case as a whole and apply that to the circumstances at issue here. The Fielding case that I reference in my brief specifically addresses the presence of other businesses located within the same vicinity. Not that it's required, but under this rational basis test, but it would seem to indicate that if there are other commercial parcels close to this specific parcel, that would be sufficient to meet muster for the court. Now, the statement of issue number 2 with respect to the appellant's brief, it specifically states that the C2 neighborhood commercial description within the zoning ordinance, it was intended to serve the needs of surrounding residents in a defined neighborhood. That's how the appellate specifically referenced that in the issue. But that's not what the ordinance states. If you take a look at the ordinance, Exhibit 27, page 203 of the technical record, it says serve the needs of surrounding residents without disrupting the character of the neighborhood. Nothing about serving only residents in a defined neighborhood. It wasn't our burden to define the neighborhood. As a matter of fact, I would submit to the court, just as Justice Bennett referenced, the community here is all rural. The neighborhood is rural. There is no spots of various neighborhoods like you would see in Franklin or Nashville. This is a rural community. This is a rural neighborhood. And there's nothing within that ordinance that requires them to serve only those residents. As you mentioned earlier on as the Kentucky line is only 3 miles. There's literally from this parcel to the Kentucky line is farms as long as the eye can see. That's it. So this was intended to serve the residents of this rural community because there's no retail food stores there, which was the primary purpose of the Bernard's rezoning application. Keep in mind, most of the cases when it references spot zoning itself is not illegal. Illegal spot zoning, where the court has found it's illegal, is when it typically serves only the applicant or one specific property owner, which is always the applicant. In this case, because they had another store on their property a mile away, why else would we be here if they wanted to only serve the Bernards? They wanted to serve the community by opening up a farm store so that all the farmers could come together to serve a need that was not being met in this Orlinda community, especially after COVID, after supply chain issues. These people need food. What better way to accomplish the 2040 growth plan as it states to preserve the agricultural nature of the Orlinda community than to allow the largest farming family in the area that farms over 2,000 acres to be able to serve the local community through their farms and other farmers.
Does the record say where the nearest food store is to the proposed store?
I want to say the record states it's out at the interstate. I don't think it was specified, but it's uncontradicted that there are no retail food stores in this area. There's no contradictory information. There are other food stores.
No Kroger in Orlinda.
Absolutely not. There's a Publix at the interstate.
Well, thank you, Mr. Sutherland.
Thank
You're
you.
way past your 8 minutes. we'll give Mr. Harrison 6.
Yeah, I drug him past it.
Okay.
It's my fault.
Good morning, Mr. Harrison.
Your Honors, welcome to Nashville, Judge McClarty. The interesting thing about the Kentucky line is we want to keep those Kentuckians out of here, particularly when they're playing Vanderbilt in basketball. That's what we want, but we can't seem to do it. But in any event, Your Honor, I represent Robertson County, Ben Harrison of the Nashville Bar. And I just want to make a few comments about Mr. Berry's argument. He wants to say that the fact that the Bernards had a store that they were legally allowed to operate themselves because they were using their own produce, and then changing that store to allow them and other farmers to be able to do the same thing, Mr. Berry alleges that's somehow irrelevant. Well, we're talking about what the character of this neighborhood is. It's all rural. And they're doing now what they did before in this same neighborhood. It's just their other farmers are being able to participate. And they just have a different building. So when you talk about the character of the neighborhood, this doesn't change the character of the neighborhood. And you know, the burden...
Well, it does sell other things too that these people don't produce, doesn't it? Sells Coca-Colas.
You know, I don't know, Judge. I don't know that there's any proof of that.
No proof in the record.
I don't think it's in the record. It's usually, I mean, it's as I understand it, it's all produce. They sell honey that's made by some other farmer in the area.
My impression was it sold other things too. So I need to check the record on that then.
I can't say that, Your Honor. I don't think it's in the record. It's primarily, if they do sell a few other things, I don't even know if that wasn't sold in the other store as well. But I don't know. I don't think that's in the record, and I apologize.
All right.
But I think that's relevant, the fact that they had been using a store like that and selling their produce and their own meats at this other store. In this same vicinity and in this same neighborhood, that defines what the character of this neighborhood is. And Your Honor knows that the burden is a very high burden that the city of Orlinda has. Mr. Berry talked about the issue of standing, and first of all, they got to show that there's an aggrievement, a corporate aggrievement that they've suffered. There's no landowner that's come forward and complained about their local property being in any way damaged or harmed because of this. There's no proof that there's no proof whatsoever that there's a traffic issue that this is going to create. It's on a rural road. It's not on a major highway, and there's just no proof whatsoever about what grievance the city of Orlinda has, other than this notion that it just doesn't fit within our zoning plan, but they don't articulate what that is and why it harms that zoning plan. Specifically, as Mr. Sutherland mentioned, since it's within 0.6 miles of the center of the area that they do have zoned for commercial. And this is not a typical commercial zoning. I'm sure Your Honor's picked that up. This is a residential zoning that is very limited. You can't put a Walmart there. You can't put a Kroger there. You can't have a typical commercial place there. This is for residential, very limited type uses, and it actually protects the city of Orlando, this type of zoning, and they have to prove, and their burden, as Your Honors know, is that this was clearly arbitrary, capricious, or unreasonable, having no substantial relationship to the public health, safety, or welfare, or is plainly contrary to the zoning laws, which is the Fallon versus Knox County case, which is directly quoted from the Chancellor's memorandum. And the Chancellor goes on to say that because the individual defendants have been selling their meats and produce there, then they made this, he's making the same argument I did, and how Mr. Berry can say that that's somehow irrelevant is beyond me. I don't understand it. I don't get it. But on the standing issue, where has they shown an aggrievement? You know, where does the city really have standing to contest this zoning solely within the county? And Mr. Berry raised that in his brief, and we responded to it under the Brentwood versus Metro case. And that was a case where they had a big billboard that they were going to put right on the edge of Brentwood, and I know your honors are familiar with Brentwood. They don't want this big billboard come just as you're coming in down Franklin Road going into the city. They don't want that. And so they did show that that was an aggrievement, but that was on a motion to dismiss. And the court said, well, you could have been more explicit, but I think you got over the hurdle on a motion to dismiss. Here we have no facts in this record.
So Orlinda has its own zoning,
Yes.
and the county has its own zoning. And so standing depends on the county zoning impacting
Orlinda's
Orlinda
zoning,
in
right.
some negative way.
Right. That's what the city of Brentwood case says, and they have just literally have not shown that. They just make lip service to, well, it kind of messes up our zoning plan, but they don't tell you why. There's nothing in the record telling you why. And there's no experts that have been presented. You know, you look at the Fallon case, and you look at all the proof that the plaintiffs put on there. They put on an astronomical amount of proof about traffic congestion, all sorts of things that are going to affect the values of the properties there by allowing residential apartments to be put in a single family residential area. And the court said, well, you know, the city needs residential apartments. They need more housing. And so, yeah, we recognize that you've proven all these bad negative things that are going to happen to the local areas, and we agree. We understand that, but you still didn't meet this burden. In contrast to that case, we have no facts in this record showing how, number one, Orlinda is being harmed, and how this really isn't consistent with a rural agricultural neighborhood. And I submit, Your Honor, that the record is clear, and I respectfully request this court to affirm the Chancery Court of Robertson County. Thank you.
Thank you, Mr. Harrison. Mr. Berry, your rebuttal.
Try to move quickly through these issues. First of all, our statement in the brief about the 2-mile radius, it is clear from the context in the entire brief, we're talking about within the county where the county has zoning authority. Obviously, the city of Orlinda is closer. If you could look at the map and see. Did not mean to mislead the court, or I don't believe opposing counsel was misled either. But I still question whether it's good jurisprudence and a good idea to base zoning decisions on what the applicant for the zoning change thinks the community needs. If the community needed more commercial development, they would rezone their own areas to attract it. They would try to attract grocery stores, if you will. There was no...
Harrison, my question is, what is the detriment to the city?
I'll come to that, if I may, Your Honor. I think that goes into the issue about standing as well, the injury. And here, as we understand the City of Brentwood v. Metro Board of Zoning Appeals case, of course, that was an administrative decision and not a legislative one, but where a rezoning conflicts with the land uses in an area, interferes with another local government's urban development plan, and there is in the record a urban development plan. It doesn't have the status of a land use plan under the law, but it's a policy that Orlinda has adopted and followed in the early 2000s, that they want to keep commercial development in the town center and out by the interstate. Orlinda has an unusual tentacle that goes all the way out to Interstate 65. To the extent that this is adjacent to the town, any sort of commercial development in that area is contrary to their land use plan. I would submit that under the City of Brentwood decision, even though it was decided on a 12B6 motion, simply having a zoning decisions that are contrary to another city's, adjacent city's land use plan gives that city standing. One thing is, we didn't, jumping to another issue about injury, this business was not in business until after this trial was over with, and then there was a building permit issued, and sometime in the next year they went into business. So we don't know there's no record obviously about what they actually sold, but from Ms. Bernard's own testimony, she testified in her deposition, and I think at trial as well, and by the way, the depositions were made a part of the record, that they were going to sell Coca-Colas and dry goods and all these other things, which are not just the produce of the farmers. I mean, not to be facetious about this, but no one goes into business for purely charitable motives. I mean, God bless them for providing food to the community, but then they're getting paid for that. It's a market economy. It's okay. This is America. You get to do that, but it's not the suggestion that this is sort of a social work is nonsense. So, thank you for your attention today, and always a pleasure. Thank you.
Thank you, Mr. Berry, Mr. Sutherland, and Mr. Harrison for your arguments. We'll take this matter under advisement. Madam Clerk, if you'll recess court.
All rise.